Maganda po yung talakayan kanina patungkol doon sa konsepto no, ng karapatan sa pagkakaroon po ng abogado. But I think just for the record, meron pong sulat yung mga abogado ni Vice President Sara Duterte na wala naman po ata talaga din silang interest at this point na dumalo either ang pangalawang pangulo o yung mga abogado po mismo. And I will read it for the record.
Madam Chair, we are still on our ground rules discussion, so that can probably wait and we will be able to discuss that.
No,
because we are now on approving the ground rules. We are not yet determining what the council or the Vice President is proposing or manifesting to us.
The hearing of the Committee on Justice is hereby called to order.
Madam Chair,
The Honorable Zamora.
as this is a continuation of the hearing held on March 18, 2026, I move to dispense with the calling of the roll.
There is a motion to dispense with the calling of the roll. Do I hear a second?
Second, Madam Chair.
Is there any objection? Hearing none, the motion to dispense with the calling of the roll is hereby granted. Can I hear a motion on the reading of the minutes and its approval?
Madam Chair, I move to dispense with the reading of the minutes held last meeting, and I move for its approval.
There is a motion to dispense with the reading of the minutes of the last meeting and for its approval. Do I hear a second?
Second.
Is there any objection? Hearing none, the motion is approved. The reading of the minutes is dispensed with and the same is approved. The Chair will address the Justice Committee. Magandang umaga po sa inyong lahat. Sa aking mga kapwa miyembro ng kapulungan, sa ating mga panauhin na naririto ngayon at sa sambayanang Pilipino. Before we begin, at bago natin ipagpatuloy itong proseso ng impeachment, tandaan natin na hindi lingid sa ating kaalaman na marami pa tayong ibang kinakaharap na problema. Let us accordingly acknowledge the pressing challenges our country faces. Oil prices are rising. The cost of basic goods is increasing. Ordinary Filipinos feel the weight of daily life more than ever. And yet, even as we undertake this solemn constitutional duty, the House of Representatives does not forget its other responsibilities. Kahit may impeachment, tuloy pa rin tayo sa iba nating obligasyon. We have, for example, acted to ease the burden of rising fuel cost, passing a bill authorizing the suspension or reduction of excise taxes. Nariyan na po ang panukalang batas, pinag-aralan, pinag-isipan, at inaasahang makatutulong sa ating mga kababayan. We also continue to work on measures that address inflation, food security, and social services. Also, just this March 2026, the House has acted on measures that directly affect the daily lives of Filipinos, passing a bill abolishing the travel tax, advancing legislation to institutionalize digital payments in government transactions, and pushing reforms to make public services more accessible and efficient. The House has also advanced key education reforms, including amendments to the Universal Access to Quality Tertiary Education Act and the Presidential Merit Scholarship Program. This strengthens support for students and investing as well in the country's future workforce. And after nationwide consultations, across Luzon, Visayas, and Mindanao, the House has pushed forward the long-awaited anti-political dynasty bill with plenary deliberations recently completed. These actions remind us that governance is a constant balancing act, attending to urgent needs while fulfilling constitutional obligations. Kahit may impeachment, tuloy tayo sa iba nating tungkulin. Ang ating serbisyo publiko ay hindi napuputol, hindi tumitigil kahit sa gitna ng pinakamabigat na tungkulin. While we scrutinize those in power, we do not lose sight of the hardships faced by the powerless. Having said that, we proceed today fully aware of our dual duty to hold public officials accountable and to serve the people who entrusted us with this mandate. And so now, we begin. Dito nagsisimula ang opisyal na pagdinig ng kasong ito. Sa ating pagsisimula, tandaan natin na ang impeachment ay patungkol sa pananagutan sa bayan. Kaya't marapat lamang na balikan natin ang ating panunumpa. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Madaling bigkasin, pero mahirap panindigan. Hindi ito simpleng ritual. Ito ay isang pangako, isang panata ng pananagutan, hindi lamang sa batas, kung hindi sa bayan. Let me lay out the agenda for today. First, we establish the ground rules or the guidelines, not as obstacles, but as safeguards. Their purpose is simple: to maintain order, to allow clarity, so that truth may emerge unimpeded. Ang patakaran ay hindi hadlang sa katotohanan. Ito ang daan upang ito'y malinaw na lumitaw. Second, we move to the initial hearing. Opisyal po nating buksan ang pagdinig sa impeachment na ito. Third, and as part of this initial hearing, we act on pending motions, request for subpoenas, and set the schedule for the next hearings. At the core of these proceedings is probable cause. That is the objective of these hearings. We shall determine whether there is probable cause for impeachment. Ngunit, paano ba natin masasabi na merong probable cause? Let us be clear. This is not the probable cause of criminal procedure. Impeachment is not a criminal trial. It is a constitutional and policy exercise entrusted not to the courts, but to the House of Representatives. As we have seen in previous proceedings against Ombudsman Mercedes Gutierrez, the classical legal definition of probable cause was not applied. And for good reason. Impeachment calls for judgment, not mere calculation. It asks not only what can be proven, but what can be justified before the people. As the late Father Joaquin Bernas said, impeachment is about what is best for the country. Hindi lang ito tanong ng kung ano ang nasa batas. Ito rin ay tanong ng kapakanan ng bayan. Consider the ground of betrayal of public trust. What does it mean? Can it be reduced to a single act? A measurable threshold? Or is it something more? Something felt as much as it is proven? Paano mo susukatin ang pagtataksil sa tiwala? Sa bilang ba ng ebidensya o sa bigat ng paglabag? We are confronted with serious allegations, threats against the president, accumulation of ill-gotten wealth, SALN violations, misuse of confidential funds, disregard of safeguards for transparency, and defiance of constitutional process. These are not trivial matters. They go to the very heart of public trust. May mga kasalanang hindi kailangang ipaliwanag, ramdam agad ng taong bayan. The truth is, betrayal of public trust resists rigid definition. And if the standard is not mechanical, neither can the threshold to examine it be mechanical. Kung ang batayan ay may bahid ng moralidad, ang paghusga ay hindi maiiwasan dumaan sa konsensya. Conscience becomes our guide, not as a substitute for evidence, but as its interpreter. Evidence tells us what happened. Conscience tells us what it means. Ang batas ang nagbibigay ng balangkas. Ang konsensya ang magbibigay ng kahulugan. Therefore, to determine probable cause is to listen, to weigh, and to decide, not by rigid formulas alone, but by what is just and right for the Filipino people. Ngunit malinaw sa atin, ang araw na ito ay simula pa lamang. Sa mga darating na linggo, sa mga susunod na pagdinig, hihimayin natin ang mga aligasyon isa-isa. Susuriin ang bawat ebidensya. Magtatawag tayo ng mga testigo. Pakikinggan ang bawat argumento at titimbangin ang depensa. Today is just the beginning. The beginning of a process that demands patience, discipline, and vigilance. At sa prosesong ito, sisikapin nating maging tapat, hindi lamang sa batas, kundi sa sambayanang Pilipino. And in the search for probable cause, let us remember that what we are conducting here is merely investigative in nature, where the question is not guilt, but whether there is sufficient basis to proceed to trial in the Senate. At this stage, in this committee, there is no deprivation. No one is being removed from office here. No one is being disqualified. No final judgment is being rendered. Those consequences, if they are to come at all, arise only in the Senate, where the trial is held, where the evidence is fully ventilated, and where the full measure of due process applies. But this is not to say that due process is absent here. Far from it. We have to remember that whatever we do here in the committee must always be in accordance with the Constitution, particularly the demands of due process. The Vice President has been invited to participate. she is reportedly prepared for a full-scale legal battle, a bloodbath, as it has been described, assembling a very large team of lawyers. She is apparently ready to face the accusations and defend herself at length. And yet it appears she will not even participate. We recall the words of Justice Antonio Tiham in the previous impeachment against Chief Justice Maria Lourdes Sereno. Failure to participate in the hearings before the Committee on Justice is tantamount to a culpable violation of the Constitution. Ayon sa pananaw na iyon, ang hindi pagharap sa proseso ay maaaring ituring na patuloy na paglabag sa saligang batas. Ang tanong ngayon, maaari rin ba nating sabihin ito sa Vice Presidente? Let us remember, the Vice President took the same oath. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Lahat ho ng kawani ng gobyerno, lahat ng opisyal ng pamahalaan, iisa ang panunumpa, iisa ang pamantayan, iisa ang pananagutan. Ang panunumpang ito ay hindi lamang pangako ng panunungkulan. Ito ay panata ng pagharap sa pananagutan at paggalang sa saligang batas. Dito sa komite, susundan natin ang saligang batas. Hindi natin tatalikuran ang ating tungkulin. Iyan ang inaasahan ng taong bayan. Hindi pag-iwas, kundi pagharap. Hindi katahimikan, kundi pananagutan. Sapagkat ang panunumpa ay hindi lamang binibigkas sa simula. Ito ay pinatutunayan sa bawat pagkakataon na tayo ay sinusubok. So regardless of the participation of the Vice President, and even in her absence, this committee will proceed. We will do our duty with resolve, without hesitation, and without delay. The Constitution entrusts the House with the exclusive power to initiate impeachment cases, and this committee stands at the forefront of that responsibility. Tayo lamang, ang Committee on Justice lamang, ang tahasang binigyan ng ganitong tungkulin sa saligang batas. In the end, this is not merely a procedural exercise. This is a test of judgment, of conscience, and of courage. Let us proceed with diligence, with fairness, with honesty, knowing that our actions today will echo far beyond this chamber. And so we return to where we began. Sa huli, babalik tayo sa ating panunumpa. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Madaling bigkasin, pero mahirap panindigan. Ang tanong, para sa lahat ng kawani ng gobyerno, para sa lahat ng opisyal ng pamahalaan, para sa Vice Presidente, tinutupad ba natin ito? Pinaninindigan ba natin ito? Iyan ang tanong na sisimulan nating sagutin dito sa impeachment na ito. Maraming salamat po. We now call the case. Committee Secretary.
Thank you, Your Honor. Initial hearing on the impeachment complaints against Vice President Sara Z. Duterte filed by Reverend Father Joel Saballa et al. And endorsed by Representative Laila M. De Lima and filed by Attorney Nathaniel G. Cabrera and endorsed by Representatives Bienvenido M. Abate Jr. and Francisco Paulo P. Ortega V.
Madam Chair,
The Honorable Jokno.
may I be allowed to make a brief manifestation
Which manifestation?
in relation to the opening statement?
The opening statement.
made by
You may
the
proceed,
Chair.
the Honorable Jokno.
Thank you, Madam Chair, distinguished colleagues, mga kababayan natin na nanonood, at magandang umaga po sa atin lahat. Marami po nagtatanong, ano ba talaga itong impeachment at ano ba ang proseso sa impeachment? Klarong-klaro po sa ating konstitusyon, Article 11, Section 3, the House of Representatives has the exclusive power to initiate all cases of impeachment, while the Senate has the sole power to try and decide all cases of impeachment. Sa madaling salita, ang Kongreso ang nagsasampa o naghahain ng impeachment case, habang ang Senado naman ang nagsisilbing hukom o tagahatol. Kaya tayo nandito sa hearing na ito ay para malaman, dapat nga bang isampa ang impeachment case laban sa Vice Presidente? Nung nakaraan, nakita po natin na sufficient in form and substance ang dalawang impeachment complaint. Ibig sabihin nito, sapat o tama ang forma ng mga reklamo at may sapat na nilalaman para umusad tayo sa pagdinig na ito. Nakita din ng committee na ang impeachment complaint ay sufficient in grounds o may sapat na batayan. Sa puntong ito, mismo ang konstitusyon ang nag-uutos sa Committee on Justice na magsagawa ng hearing. Ano naman ang ihihiring natin? Siyempre, walang iba kundi ang ebidensya at testigo. Our duty is clear, Madam Chair. This committee must secure and verify every piece of evidence, and we must protect every witness so they may give their testimony under oath. Ito ay naaayon mismo sa Section 7 at 8 ng Rules of Impeachment. Itong dahilan kung bakit po tayo naghain ng motion para makuha ang kopya ng SALN ng Vice Presidente at para bigyan ng proteksyon ang testigo na si Mr. Ramil Madriaga. Ang impeachment case na ito ay dadaan sa butas ng karayom. This is the only way for the truth to come out. Pagkatapos ng committee, boboto po ang buong Kamara at magpapasya kung dapat ilitis ang kaso sa Senado. At sa bawat hakbang, nakatutok ang buong bansa para bantayan ang proseso. Maraming salamat po. Thank you, Madam Chair.
The manifestation of the Honorable Jokno is noted by the committee.
Madam Chair.
The Honorable De Lima.
Also a brief manifestation and a question to the Honorable Chair and the Committee
With the
Secretariat.
indulgence of the Honorable De Lima, we would like to tackle first our ground rules before we proceed to your subsequent manifestations and questions to the committee.
Thank you, Madam Chair. Thank you.
Madam Chair.
Regarding the ground rules, we would like to acknowledge Vice Chair Zamora.
Thank you, Madam Chair. Bago po tayo magsimula sa deliberasyon ukol sa pagtukoy ng probable cause sa impeachment proceedings na ito, kinakailangan magtakda ng ating chairperson ng ilang panuntunan upang matiyak ang maayos, patas at episyenteng pagtatalakay. Ang komite ay may 38 na regular members. Ang quorum ay 1/5 ng kabuuan. Ang ex-officio members ay may boses at may boto. Ang mga nais magsalita ay kailangan makipag-ugnayan sa committee secretary upang maitala ang kanilang pangalan. Magkakaroon tayo ng alternating recognition ng minority at majority na may 5 minuto bawat isa. Maaari tayong magbigay ng second round kung may oras pa po. Hinihiling ng chairperson na hintayin muna ang kanyang pagkilala bago magsalita upang mapanatili ang kaayusan. Sa mismong pagdinig, ang mga resource persons ay susuriin ng mga miyembro ng komite alinsunod sa Section 7 of the Rules of Procedure in Impeachment Proceedings. Ang mga resource persons ay hindi papayagang magsalita o gumawa ng mga interjection malibang kung at hanggang sa sila ay kilalanin ng ating chairperson. Tanging ang mga miyembro ng komite lamang ang may karapatang suriin o i-cross-examine ang mga resource persons. Ang mga partido ay maaaring humingi ng pahintulot mula sa chairperson na magsumite ng mga tanong na itatanong ng ating chairperson kung sa kanyang opinyon ay kinakailangan ang mga ito para maging malinaw ang talakayan. Ang pakikilahok ng mga abogado ng mga partido o resource persons ay limitado sa pagpapayo sa kanilang mga kliyente tungkol sa kanilang mga karapatan sa ilalim ng konstitusyon. Dapat silang sumunod sa wastong kagandahang asal at hindi sila papayagang magsalita o gumawa ng mga interjection malibang kung at hanggang sa sila ay kausapin o kilalanin ng chairperson. Mga kasama, impeachment is an extraordinary constitutional process. It demands sobriety, discipline, and unwavering respect for the rule of law. Hindi personalidad ang ating hinaharap ngayon, kundi ang ating constitutional duties. Thank you very much, Madam Chair.
Can we hear the necessary motion for the adoption of ground rules?
Madam Chair, I move to adopt the ground rules as stated earlier.
There is a motion to adopt the ground rules read by the Honorable Zamora. Do I hear a second?
Madam Chair,
Is there any objection?
discussion. Madam Chair.
The Honorable Rodriguez.
Madam Chair, the right to counsel is assured by the Constitution. So therefore, the respondent here has always have the right to counsel. In fact, in many cases, our rules of court is suppletory to the rules of impeachment in the House. And so therefore, this representation believes that first, they are entitled, counsels for both sides are entitled to send questions, and I agree with that, Madam Chair. But what I would like to emphasize is that the Vice President can always designate their counsel to appear in all the proceedings, so that we should be able to state there that the right to counsel, the right to be heard by herself or counsel is assured by the Constitution. But we know the response of the proponent of the motion as to that particular observation.
If I may confirm, the Honorable Rodriguez, you would like the committee to acknowledge the right of the counsel even in the absence of the respondent.
That's correct. Based on jurisprudence, Madam Chair, that although this is not a criminal proceeding, it is akin to a criminal case because we are trying to remove and there is also perpetual disqualification. And so, in other words, the Vice President can send her counsels here to appear for her. In fact, the right to self-incrimination is there. And a person who is now being investigated has the right to already not take the stand or at the time she wants to appear to be able to invoke it when she is asked an incriminatory question. So that is the position of this counsel. Thank you, Madam Chair.
Of course, based on the ground rules that was read by the Honorable Zamora, the right to counsel is described as assistance to clients or to the parties. Now it is being proposed by the Honorable Rodriguez that the same be acknowledged even in the absence of the respondent or the parties. May I hear the comment of the members of the Justice Committee?
Madam Chair.
The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I agree if that is on the presentation of the complaint's evidence. But at the time the respondent will be presenting her evidence, she must be present, because who will answer clarificatory questions in cross-examinations of what will be presented? She is the only one. The counsel are not witnesses in this particular case. So I hope my colleague will agree that at the time the respondent is given the opportunity to present her evidence, she must be present. Thank you, Madam Chair.
Would you like to clarify the extent of the participation that you are proposing?
Yes, Madam Chair. What I am proposing is, at the time that we have concluded the presentation of the evidence of the complainants, and it will be the turn of the respondents, then the respondents or her witnesses must be present, because they are the only ones who can answer clarificatory questions or cross-examination questions of any of the members of this committee. The lawyers of the respondents are not witnesses to the said defense of the respondent. So it is a must, Madam Chair, that she must be present unless she will waive the presentation of her evidence when it is her time to present her evidence pursuant to our rules of impeachment, Madam Chair.
For purposes of accuracy, Honorable Vice Chair Dumogan, you are proposing that the respondent's counsel, even in her absence, be allowed to present the evidence. But for purposes of clarificatory hearing, it should be the Vice President herself who should be present and answer the questions before the Justice Committee.
That's exactly correct, Madam Chair.
Thank you. Any other member who
Madam
wish to
Chair.
manifest? The Honorable Rodriguez.
Madam Chair, the right against self-incrimination is very clear. Under our rules, the criminal procedure rules, which are suppletory, because our rules are very, very pithy in terms of the procedure. 2 points, Madam Chair. The respondent has the right not to appear, and therefore she does not need to be present, because that is the right of a respondent, akin to a accused in a criminal case, as decided in the cases, Madam Chair. That's number one. Number two, the counsels here are not only to advise on the legal rights, they have the right to cross-examine, because the Vice President will not be present. If she's present, she cannot cross-examine witnesses, because she has lawyers. So therefore, 2 points. The rule that requires that the participation is only to advise the legal rights of the witness is on the rules on the investigation in aid of legislation. That is expressly found in the rules in aid of legislation, the hearings. But it is not found in our rules. I've been reading our rules of procedure. There's nothing here that limits it to only advising. Therefore, in an adversary proceeding like this, we have to therefore hear the counsels if they wish to be present, but if not, then that is also the lookout of the respondent. But I believe that we should be clear in our rules that the presence of counsel of the respondent has the right to cross-examine directly the witnesses for the complainants. And secondly, there is no need for the Vice President to appear in hearing, because that is her right not to be able to appear, and we can make conclusions out of her non-appearance. No need for her to appear. Thank you, Madam Chair.
Madam Chair.
Madam,
The Honorable Chua, are you raising your hand?
No. Madam Chair.
The Honorable Vice Chair Dumogan.
The first part of the point had already been settled. Under our own rules, which is the subject of the motion, the counsel of the respondents are allowed to cross-examine by writing their questions, submitting it to the chair. What I am pointing out, Madam Chair, is at the time the respondent is given the opportunity to present her evidence. Well, counsel may present her evidence, but she must be present, or the witnesses that she is presenting must be present so that the members of the committee will have the chance to examine or ask clarificatory questions from them. The counsels are not witnesses to the defense of the respondents, Madam Chair. Thank you, Madam Chair.
For the guidance of the justice members, part of the proposed rule is giving opportunity to the complainant and the respondent and their counsels to submit questions to the chairperson so that they may be raised in the deliberation if no justice members are raising similar questions. Let us all be guided as well that the hearing proper in the Justice Committee is akin to a preliminary investigation. So, let us be guided by the fact that as well, that we're trying to establish here is merely probable cause, which means a justification to be able to proceed to trial, which will definitely happen not here, but in the Senate. The Honorable Chua.
Thank you, Madam Chair. Madam Chair, let me read what is provided under our rules, the rules of procedure in impeachment proceeding. Under Section 7, it provides that if the committee finds that there is sufficient ground for impeachment exists, the committee shall conduct a hearing, which we are now doing. The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. Therefore, Madam Chair, it is very clear under our rules that it is only the members of the committee who can participate with respect to the examination and cross-examination of the members. Why? Because, like what you said a while ago, this is akin to the preliminary investigation wherein it is the investigating officer or the investigating city prosecutor who is asking clarificatory questions. We are not yet in the trial where the lawyers or counsel of the defendant can cross-examine the witnesses. Now, this can also be we can also be guided by our rules of procedure governing inquiries in aid of legislation, which the Honorable Rufus Rodriguez mentioned a while ago, that under Section 13, appearance of counsel. Here, the participation of counsel for witness during the hearing and while the witness is testifying shall be limited to advising on the legal rights of said witness. Why? Because this is a committee function. So ganun din po dito. Ito pong ginagawa natin is also a committee function. The cross-examination, ang purpose po ng cross-examination dito is just to ask or just to clarify questions. Hindi pa po ito yung talagang trial proper wherein we can cross-examine thoroughly the witnesses. Thank you, Madam Chair.
Madam Chair.
Thank you. The Honorable De Lima.
Thank you, Madam Chair. I concur with the views expressed by the Honorable Joel Chua. As expressed very clearly by the Honorable Chair earlier, the proceedings today or the proceedings from now on, henceforth, would be the determination of probable cause. And therefore, this proceedings is indeed akin to a preliminary investigation. There are no formal direct examination or cross-examination in the proceedings before the prosecutor's office. Yes, we can recognize the respondents and the complainants' right to counsel, but their role ought to be limited because this is only preliminary investigation. Role like identifying affidavits can assist their clients, can assist the complainants, or can assist the respondent. But if they have questions, as expressed and as already laid down in the ground rules read by the Honorable Representative Zamora, they can course it through the chair. In that case, they are afforded the right to confront, the right to ask clarificatory questions. This is not a full-blown trial yet that happens in the Senate. Just to repeat, this is akin to preliminary investigation, determination of probable cause. The proceedings or the hearings before the prosecutor's office, and this is the prosecutors, the Committee on Justice, is actually also limited. And no full-blown examination, whether it's direct examination or cross-examination, being conducted or held at that point. So I think it's very clear, as expressed by the Honorable Chair and also indicated in the ground rules. We are not denying the parties their right to counsel. They have the right to counsel. They can assist for purposes especially also of asking clarificatory questions, but we have our own rules here, coursed through the Honorable Chair. Thank you.
Madam Chair.
The Honorable Ridon and then the Honorable Rodriguez.
Well, maganda po yung talakayan kanina patungkol dun sa konsepto ng karapatan sa pagkakaroon po ng abogado. But I think just for the record, meron pong sulat yung mga abogado ni Vice President Sara Duterte na wala naman po ata talaga din silang interest at this point na dumalo either ang pangalawang pangulo o yung mga abogado po mismo. And I will read it for the record.
Madam Chair, we are still on our ground rules discussion. So that can probably wait and we will be able to discuss that.
No,
because we are now on approving the ground rules. We are not yet determining what the Council or the Vice President is proposing or manifesting to us.
For the guidance of the Justice members, there is a pending motion for the approval of the ground rules read by the Honorable Zamora. Perhaps we will be proceeding to the letter sent by the lawyers of the respondent after we address the motion for the approval of the ground rules.
Yes, Madam Chair, but just to make the point that even if we talk about a conceptual matter relating to the right to counsel, if the counsels themselves are actually questioning these proceedings and the Vice President herself is questioning this proceeding, I think that needs to be placed on record, Madam Chair. So I will read it. For two Narvasas and Salazar.
Madam Chair.
The Honorable Ridon
That will
is
be out of order.
requested to defer the discussion on the letter of Fortuna Narvasa until we address the pending motion before the committee. So if we can go back to the motion, the
Madam
same
Chair.
has been seconded already.
Other discussion because there were interjections.
That is with regards to the
rules.
ground rules.
Yes, Madam
The Honorable Rodriguez.
Madam Chair, there is here a statement that in our rules, only members can ask questions. And I would refer now to Section 7. Committee finds, and then the committee shall conduct a hearing and examination and cross-examination by members of the committee. Very clear. However, Section 7 shall obey the Constitution of the Republic of the Philippines. The Bill of Rights, Madam Chair, Article 3, provides that the right to be heard by himself or herself or to counsel is inviolable. It is in paragraph, in section, in the rules, in the Bill of Rights, is in the section on Section 2,
Reiterate to him.
and then also on custodial Section 2 and Section 4. So, Mr. Chairman, I am saying that we just have to give the right, otherwise there will be no due process. If only the members
Chair.
can ask, we should allow,
Madam
can I
Chair.
finish first,
they
Madam
have
Chair?
the right.
I have allowed my good chair to finish, so let me finish my manifestation. So therefore, Madam Chair, it is very clear that councils should be allowed to cross-examine. Now, the issue here is that the rules provide that they submit the questions to the chairman. Will the chairman have the discretion to read or not? Or everything that will be given to the chairman will be read?
To answer the question of the Honorable Rodriguez, so long as the question is germane to the discussion pending before the committee, the chair will read the questions which are being submitted or which will be submitted by the councils of the parties. That includes the council of the respondent.
Thank you, Madam Chair. But
Madam
just to be
Chair.
able to state that this representation believes to be able to afford really procedural due process as pronounced in the leading case of Angtibay versus CIR. The 7 cardinal rights of a person who is accused, in this case akin. We are really, this is even more than a criminal case because we are trying to remove the official who had the highest votes in the history of this country as vice president. So what I'm saying, Madam Chair, we should allow the councils to appear if they so wish and be able to cross-examine the witnesses of the complainants. That is the way to be able to afford the opportunity of procedural due process as is written in Article 3 of Section 1 of the Constitution.
Madam
Let
Chair.
us be guided by the fact that this is not yet the trial.
Madam Chair, may
So
I be
what
allowed?
will happen before the Justice Committee is indeed merely a clarificatory hearing. Trial is different because, as has been repeatedly stated, only the Senate can conduct the trial.
Madam
What
Chair.
will happen before us is merely clarificatory hearing, and those questions are to be raised by the justice members. Of course, the lawyers of the respondent are free to attend the hearings, but with respect to their participation, I think that has been addressed in the proposed ground rules, that their questions may be submitted to the justice chairperson, who will be reading those questions to be answered by the resource persons.
Madam
Let
Chair.
us draw the line between the clarificatory hearing, between the Justice Committee and the trial, which will happen in the event that there is probable cause in the Senate only.
Madam Chair.
The Honorable Chua.
Thank you, Madam Chair. To answer the manifestation of my professor, the Honorable Rufus Rodriguez, there is no violation of due process, Madam Chair. Why? Because the respondent was given the opportunity to answer. That was the time when she is allowed to give all her answer. Now, sinasabi po natin that this is akin to preliminary investigation. Sa preliminary investigation po ba, did we allow the complainant and the counsel to cross-examine? No. It was only the investigating prosecutor who is allowed to propound question to clarify. Hindi pa po ito yung full-blown trial. And us, as member of the Justice Committee, that is our job to ask clarificatory questions. Yun po yung intention nito. To do otherwise, kung iba po yung nasa isip nito, dapat clearly and expressly nilagay po dito sa ating rules na yung examination and cross-examination can be conducted by members of the committee and or counsel and the complainant. Kaso hindi naman po ganun eh. Sa buong Pilipinas, wala po kayo, never po nangyari sa preliminary investigation nagkaroon ng cross-examination or nagkaroon ng opportunity na mag-cross-examine ang counsel at ang complainant. Thank you, Madam Chair.
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable Zamora and then the Honorable Vice Chair Dumogan.
Madam Chair, I reiterate my motion to approve, to adopt
And-
the ground rules as I earlier stated.
In the interest of due process, let's hear as the last manifestation on the issue of representation by counsel, the Honorable Zamora, the Honorable Dumogan, and then we rule on the motion to approve the ground rules. Honorable Dumogan.
Thank you, Madam Chair. As I said, we fully is in the motion that respondent is entitled to counsel. Her counsel are entitled to ask clarificatory question, but it must be coursed through the chair, who will read the questions. That is the same in a preliminary investigation in a criminal case. But on the other hand, after the complainants had presented their evidence, it will now be the turn of the respondent. When the term of the respondent will come, counsel can possibly present also the evidence of the respondent. But as I said, the respondent must be present because who will now answer clarificatory questions from the investigators? The members of the committee are considered as the fiscal conducting an investigation. So, who will now answer the clarificatory questions of this committee if the respondent will not be here? So, anyway, it will be her right if she does not appear. But to me, it will be a waiver of her right also to answer clarificatory questions of any members of this committee. Respectfully submit.
Thank you. At this juncture, we shall now resolve
Madam Chair.
the motion. I think
Another-
we've heard already
No,
all
another
your meaningful and significant manifestations on the right to be represented by counsel. So with the indulgence of the
Madam
Honorable
Chair,
Zamora.
there is a next ground rule which I would like to again manifest. We're finished with the representation and
Okay.
presence.
You may proceed on the
I'd
next ground rule.
I would like to ask our Vice Chair, after the issue of the questions to be sent, what is the next ground rule? Because I have also a manifestation on that.
The last one is ang pakikilahok ng mga abogado ng mga partido o resource person ay limitado sa pagpapayo sa kanilang mga kliyente tungkol sa kanilang mga karapatan batay sa konstitusyon.
Madam Chair, I would object to that because precisely the rules of investigations in aid of legislation, that is precisely included. But it is not included in the rules of impeachment. Plus, secondly, lawyers will be allowed, in fact, that will contradict the previous ground rule because the lawyers of respondents are allowed to send questions to the chairman. So if you are preventing them only to advise counsel on their legal rights, that is what is stated in the rules in aid of legislation, then that should fall. Because we have allowed already in the first ground rule that there will be questions on cross-examination to be submitted to the chair. So the counsel is not limited to giving advice on the legal rights, the right to counsel, the right to right against self-incrimination, but really to participate through the chair. So I therefore move that we remove the
Madam
last
Chair,
one.
if I may comment,
The Honorable
please.
Zamora.
Madam Chair, number 8 and number 9 of the ground rules are not inconsistent with each other. Number 8 refers to the right of the parties to submit questions to the chairperson in case, and the chairperson has the right or has the discretion to propound these questions to the
resource
parties.
person.
For number 9, Madam Chair, the statement that the parties and their counsels, the counsels are limited to advising their clients about their rights under the Constitution is actually a very general statement that, yes, we should follow what is stated in the Constitution. So, In fact, it says here, dapat silang sumunod sa wastong kagandahang asal at hindi sila papayagang magsalita o gumawa ng mga interjection maliban kung at hanggang sa sila ay kausapin o kilalanin ng chairperson. So this is in fact a very general statement, Madam Chair. And again, as we are in a preliminary investigation stage, we are not violating the right of the respondent to counsel. In fact, I would like to make it a point that the respondent and his counsel and her counsels are not present. Thank you, Madam Chair.
Thank you. Any other manifestation? We are
Madam
on
Chair.
number 9
Madam Chair. Madam Chair.
ground rules of impeachment, of the
Madam
hearing
Chair.
proper. The Honorable Tino.
Madam Chair, this is just a request for copies, even electronic
Yes.
copies of the ground
Yes,
rules.
may we
under
direct the committee
consideration.
secretary to provide the members with a copy of the ground rules?
Madam Chair, manifestation.
The Honorable Diaz Puno.
I refer back to the comment of the chairperson earlier that the questions being raised by the lawyers be coursed through her for determination on whether or not they are germane to the discussion. This leads us, Madam Chair, to the question of what is this committee tasked with deciding? Are we going to decide veracity or non-veracity of evidence? Or are we merely made to decide whether the evidence presented by the complainants are relevant to the complaint that they have submitted? When we forward whatever decision we make to the Senate, do we say that contrary to a preliminary investigation, that there is probable cause? I do not think that that is the obligation of this committee. I believe, Madam Chair, that the obligation of this committee is to verify that the witnesses presented will present testimony that are consistent with the complaints that we have already ruled as of substance and form. So maybe the right to counsel is not properly addressed here because we're not after truth or falsehood of the evidence that's coming in. Merely relevance to the complaint that have been submitted by the complainant. When we elevate it to the Senate, we are not saying that anything is true or not true. We're not saying that anybody is guilty or not guilty. We're merely saying that the complaints have been found to be in form and substance. The witnesses presented have been consistent with the complaints that have been submitted, and that is going to be the substance of the decision that this committee will make, Madam Chair.
Thank you. And in addition to that, let us be reminded that part of the ground rules is allowing the lawyers of the parties, that includes the lawyers of the Vice President, to submit their questions to the chairperson so that the chairperson can raise them to the resource persons or even to the parties in the case or the witnesses, so long as the same is germane to the impeachment proceedings. So with that, may we proceed
Chair.
to
Madam
rule
Chair.
on the motion? The Honorable Ko and then the Honorable Jokno.
Thank you, Madam Chair. Madam Chair, I would concur with Representative Joel Chua and the current stipulation of the ground rules and find no contradictions, whether it be in the Constitution, in the House rules as we speak, and in the principles of due process that we are providing the respondent as of now. Also to clarify, the process that is on the floor right now is so that this committee, at the end of the succeeding hearings that we will be holding, makita natin kung may probable cause or hindi. Kung mag-proceed na dapat mag-proceed to a full-blown trial o hindi sa Senado yung complaints at bar. And to that end, isang step beyond sufficiency of substance and yung relevance na laman ng mga complaints, yung dapat i-determine ng mga members of this committee and the committee at the end of the day. That's why, for me, kailangan din po yung hindi lang presence ng respondent, but rather, no, yung meaningful advice that the lawyers can provide, which is sufficiently detailed naman na po doon sa ground rules na pinopropose. So, Madam Chair, if necessary, I would like to second the motion as on the approval of the ground rules.
After the manifestation of the Honorable Jokno.
Thank you, Madam Chair. To ensure consistency and as well avoid the possibility of any litigation that may question the rules of the committee, perhaps the committee could entertain a possible amendment to the proposed House rules. The last provision, to make it clear, could state that the participation of counsel shall be limited, number 1, to assisting their client, number 2, to submitting questions to the chair, and number 3, to filing whatever appropriate manifestations they choose to, and if required by the committee, a memorandum as stated in the rules on impeachment. That way, there can be no issue as to, no one can argue that the right to counsel is being denied by the committee. I would make so move, Madam Chair.
Second.
That is a motion for, if I may be clarified, Honorable Jokno? Because there is a pending motion as well for the approval of this ground rules. So may we hear first, before the second motion, that is for the amendment, if the proponent of that ground rules is accepting your proposed amendment.
Madam Chair, can I just insert this manifestation?
Kindly wait to be recognized, Vice Chair Dumogan.
Madam Chair,
please.
I accept the restating of the ground rules as amended by the Honorable Jokno, and I would like to point out that these are just ground rules and not rules of the House of Representatives. These are just the ground rules of the Committee on Justice.
With the acceptance by the proponent of the amendment by the Honorable Jokno, may I hear the necessary motion to approve the amended ground rules?
So
Vice
moved.
Chair Zamora.
So move, Madam Chair.
Second, Madam Chair.
There is a motion to approve the amended ground rules by the Honorable Dumogan. It has